Welcome to the fourth lecture that will be covering the legal construction of the employment environment. Let me advance to slide 146, which is a little bit of backtracking where we were during the end of the third lecture where we had some technical difficulties. So I'm going to retrack so we can talk in one lecture about the topic that I was unable to complete. Just a second, almost there. There we go. So we're talking about, actually I cannot do that. We're talking about implementing the employment decision, and we're going to talk about references and verifying employment eligibility. It's a very good idea to check references. You're really accomplishing a couple of things by doing so. One is that you may get useful information, right? I mean, you may find out either this person that you're about to hire is awesome and amazing, and so your decision to hire them is reinforced and you feel really good about it. Or it could be that you find out something that makes you think, maybe I should not be hiring this person after all. And that, of course, is a good outcome. In some sense it's an unfortunate outcome, but it's a good outcome in that you don't have to go through the hassle of hiring somebody and training somebody and then they don't work out and then you have to restart that process. But many times, honestly, when you check a reference, you don't get any information. Either the person with whom you are checking the reference doesn't return your call, or they give you a non-answer such as, oh, we're not supposed to give out that kind of information, or they give you very kind of mealy-mouthed responses, and you kind of leave the call thinking, gosh, that was kind of a waste of time. Well, in some sense it's a waste of time. You didn't get the information that you were seeking, but in another way, you got exactly what you needed. Because one of the big reasons we check references is to be able to defend ourselves against a negligent hire case. And the good news is that that call that you just made in which you didn't get any information may well have saved you from the negative impact of a negligent hiring lawsuit in the future. So yes, take those calls. When you get nothing, be glad about it, because that's actually pretty good news. And be sure to document the call. Document who you spoke to, get their first name and last name. Note the number that you called to reach that person. Note that person's title. Give the date that you made that call. You might even want to give the time of day that you made the call. You might want to note the length of the call and certainly what transpired during that call. Because let's assume for a second that that person that you hired that you weren't able to get any information on through the reference check ends up having something pretty bad in his or her background that you were unable, despite your best efforts, to uncover. And that bad actor, after he's hired by you or she's hired after you, injures somebody. And that person who is injured now sues your organization for negligent hiring. Well, you open up your file and you say, you know what, I'm so sorry that you were injured, but we tried everything to avoid this. We tried to find out bad stuff in the hopes of protecting folks, but despite our best efforts, we weren't able to uncover anything, and here's the proof for that. So checking references can be very powerful evidence in a negligent hire case. And you want to check recent references most importantly, especially if there's gaps in the employment. Could be that time, that gap of employment was spent in prison, for example. Or it could be that the reason that there's a gap is that person was fired for something pretty concerning. So you definitely want to check the references. No news really is kind of good news. We already talked about compelled self-publication. This is when somebody is fired for an untruthful reason. The employer fires Bob because the employer believes that Bob stole. The employer doesn't tell anybody else in the world that it thinks Bob stole, but Bob now has to go to job interviews to find another job. And during that job interview, it's very likely that the potential employer asks Bob, well, why did you leave your last employer? And then Bob is forced to say, because of course Bob's going to tell the truth, he's forced to say, well, my former employer thinks that I stole, but I didn't. I didn't steal, but they think that I did. Well, of course, that potential employer is thinking, gosh, maybe Bob is telling the truth. Maybe he really didn't steal. Or maybe he did. And you know what? We have a list of 30 other candidates, and none of them have an allegation of of stealing, as far as we know. So Bob is now going to the bottom of the hire pile. In other words, we're never going to hire Bob. And so, as a result of Bob's need to publish or to communicate that defamatory statement or position that the employer has taken, Bob is being injured. He's not getting the positions that he wanted. So he's compelled by the interview process to publicize the defamation about himself. We talked before about defamation, and we decided, or we discussed how it's necessary that the defamer actually publish the defamation somehow. Me saying to you, I think you're an awful person, isn't defamation. It's only when I tell it to a third person, I think Bob is an awful person, that it becomes defamatory. But if the employer never says to anybody other than Bob, I think you stole, there isn't any publication, so therefore there can't be defamation, unless, of course, this compelled self-publication. Some employers intentionally many employers, because of the automation of processes, have codes that they use to identify reasons why people are no longer employed. You know, a retirement code, a voluntary resignation code, a layoff code, those types of codes. But then there would be some for-cause codes, and this is useful information for the employer to have so that the employer doesn't inadvertently rehire a bad apple. Well, one of those codes that sometimes employers have is something like theft or something along those lines. And so you can see how that's useful, because it's good to know that this person was fired for theft, so we definitely won't hire that person back. I mean, there could be reasons that you might decide to rehire someone. For example, somebody who had poor attendance. I mean, that's not a good thing, but, you know, in a pinch, maybe you do go ahead and hire that person, especially if it was, you know, a few years ago and they've got a good explanation as to why they've resolved whatever that issue is. But theft, you're probably not going to rehire that person. So you can see how that information is useful, but you can also see how it could result in some defamation concerns, because if you tell the person you are a thief, and then the person has to repeat it, now you face a defamation claim, at least the possibility of that. But let's say you recharacterize that termination. Instead of saying to Bob, we think you stole from us, you instead say, Bob, we think you violated company policies and procedures. That is a much less defamatory statement. And probably whatever happened, even if Bob didn't steal something, I'm guessing he probably did bend some rules. I mean, it's possible that there's just been a complete misunderstanding, but probably more likely there's been some kind of bending of rules. Maybe he took some things home that he wasn't supposed to. Maybe he forgot to follow the correct procedures in terms of handling things. And so there's probably truth to that. And even if there isn't truth to it, it's hardly a terrible, terrible indictment of somebody to say they failed to follow a particular procedure. So you can see how if you give that reason to Bob, now when Bob has to self-publicize that to the next employer, it's quite a bit harder to say that's defamatory. Well, my former employer fired me because I failed to follow some policies and procedures. So that is the reason why some employers try to avoid those very emotional codes like theft or things along those lines. Now, would a compelled self-publication tort theory work in Texas? You know what? I don't know that for sure. I tend to think probably not. But again, why take the risk if you're the employer? There's no need to say, you stole from us, we fired you, and possibly setting yourself up for some kind of a negative outcome later on. Now, you may be thinking to yourself, well, but if Bob really did steal from us, you told us before that the truth is a defense, a complete defense to defamation. In fact, it's one of the elements of defamation that it be a false statement. Well, you're right, but keep in mind that the jury is going to determine whether it's truthful or false. And sometimes, especially if there's been a passage of time, it may be more difficult for you to categorically prove it now at a later time. And so something that you know to be true possibly could be viewed in a different light by a jury at some later date. So that's what compelled self-publication is about, and that may be one reason why your employer shies away from the very kind of emotional reasons for dismissal, such as theft. Let's discuss after acquired evidence as well. This has to do actually in the litigation circumstance. Imagine that Bob lies on his resume. He says that he has a college degree in accounting. In fact, he quit college after 2 years. Your business doesn't check to confirm that Bob actually got his 4-year degree. Bob goes to work with you. He's been there 20 years, and actually he's done a pretty decent job. Then there's some kind of, we'll say there was a layoff. He's been pretty good, but there's accountants in your department that are better than he is. And so the decision is we're going to get rid of Bob. Bob files a lawsuit. Maybe he's alleging age discrimination or race discrimination, or who knows what the category is. But anyway, he files a lawsuit about his termination. Through the discovery process, both sides exchange relevant information, and one of the things that is asked that the employer is going to do is say, well, you know what, we'd like to get Bob's college transcript. So that is provided, and when you see, wait a second, Bob told us he had a bachelor's in accounting, but this shows that he only has courses in the freshman and sophomore level, and in fact, he doesn't have any degree at all. Well, at this point, the business might say, well, gee whiz, if Bob had been honest with us at the time of the interview and said to us, hey, you know, I don't have my degree, I only have the first 2 years, we wouldn't have hired him. Also, let's say Bob had lied to us, just as he in fact did, but we had found that out. We had actually said, Bob, show us your transcript before we make the hiring decision. And Bob had showed the transcript, and we said, well, Bob, this isn't a bachelor's degree. This is only 2 years of college. You lied to us on your resume. We're not going to hire you. So either way, the employer says, you know what, we never would have hired Bob if he had been honest or if we had discovered his deceit. And so therefore, we shouldn't be responsible for this lawsuit filed 20 some odd years later, because we never should have been in this position to begin with. And so we should be excused from lawsuit, even if Bob can somehow prove that we discriminated against him as the basis for our termination. Bob's response, of course, is, well, you know, I mean, okay, yeah, I did mess up 20 years ago, but number one, that's 20 years ago. Number two, you did hire me, and I did work for you for 20 years. And my wrong doesn't make your wrong go away. You still discriminated against me when you laid me off. And so Bob says, that lie 20 years ago, that's irrelevant. Well, the courts would have disagreed with both the employer and the employee in this situation. The way the courts would handle this and say, you know what? We look at when the employer finds out the information. There's a particular date that the employers got those discovery documents from Bob's attorney. Let's say that date is June 17th. Well, on that date, the employer knows that Bob lied on his application. And so on that date, the employer probably would have terminated Bob. And let's assume that the employer had a consistent practice of firing people who engaged in significant resume fraud, even if it was years after the fact. Let's assume that that's a provable fact. And so then the court would say, well, okay, looks clear that Bob has engaged in significant resume fraud, and it's clear that this employer does fire people for that. And so therefore, the date that was given up in discovery is the date that Bob appropriately would have been fired. So Bob would only be entitled to damages if he proves his case from the date of his layoff until the date of that discovery. He's going to be not eligible for any front pay, and he even won't be eligible for back pay up to the time of trial. And of course, he still has to prove his case. I mean, it's not a given that he's going to be able to persuade the jury that he was a victim of discrimination. But he won't have to somehow or another defend his decision to lie back 20 years ago. So that's how the after acquired evidence works. The after acquired evidence kicks in when the employer actually finds out about it. And whatever the employer would have done without a discriminatory motive under those circumstances, on that date is the date that that we treat that decision having been made. So in this case, on June 17th, Bob isn't going to be able to collect any back pay for June 18th or June 19th or June 20th, even if Bob is able to persuade the jury that, in fact, his termination was unlawful. Defamation, we've already talked about this. The most common way that this raises in the employment context is when an employer gives a reference, a statement, or information of some type about a former employer to a prospective new employer. And again, this is one of the reasons why it's highly, highly recommended that you not give meaningful references for former employees. It's probably fine to give dates of employment, also titles, perhaps even pay ranges, although I would get the former employee's agreement before you did something along those lines. But what you don't want to do is give a substantive response. And you may say, well, why not? I mean, let's say Bob was a great employee, and so I would only be saying positive things about Bob. Well, there's a few reasons, even in that situation, you don't want to give a reference. For one thing, let's imagine you get a call and they say, and the person calling you up says, well, tell me about Bob. And you say wonderful thing after wonderful thing. Oh, he's always on time, always hardworking, goes the extra mile, great team player, really smart. And then the person says, well, what's the worst thing that you saw about Bob? And you might say, well, Bob sometimes had bad breath. He liked to eat a lot of garlicky and oniony things for lunch, and sometimes after lunch his breath just wasn't the most fun to be around. Well, it could be that this employer is really grossed out by bad breath. And so he might be saying, oh, okay, no way am I hiring Bob. I'll hire the person who shows up to work late and who's lazy before I hire somebody who's got bad breath. So even though your reference was tremendously positive, and even though it seems like your one criticism wasn't really at the core of the job, it could still cause problems for Bob. And so that's one reason you don't want to give even a very positive a reference, because it could be defamatory. Another reason is that if you give Bob an altogether positive reference and then Sally wants a reference, and you know what, your opinion of Sally's kind of mixed. I mean, there's good things, but there's also not so good things about Sally. And so you tell Sally, I'm sorry, Sally, I just can't give you a reference because I'm concerned that I could be asked a question and it might not be fully positive. Well, let's say that the same employer who hired Bob and for whom you gave that great reference now is calling you about Sally and says, hey, you were so helpful about Bob. You said so many wonderful things about Bob. Tell me about Sally. And you say, I'm afraid I can't answer that question. Well, no, I just want some kind of reference information you gave about Bob. So, just kind of that same stuff, attendance, how prompt he was, how hardworking he was he a good team player, all that kind of stuff. That's just what I need about Sally. I'm afraid I can't give that to you. Oh, well, has there been a change in the policy of your organization? I would prefer not to answer that question. You can see right there that you're communicate bucket loads of information without saying anything. Now, that's hard to become defamatory, to be honest with you, because you're not actually saying anything negative about Sally. But sometimes silence can be twisted in a certain way. And so better just to avoid that whole area entirely. Because again, what are you getting out of it? Bob may be getting something out of it. Maybe even Sally's getting something out of it. The future employer is definitely getting something out of it, but you, not so much. So name, rank, and serial number is pretty much what you want to do with defamation. Here is a slide. Again, this is refreshing our recollection that any statement that is going to be defamatory has to be false. And these are the elements that the plaintiff would have to prove. We talked a little bit about qualified privilege in a previous lecture. This is most states, including Texas, have a statute that permits former employers to give employment references to their former employees, and they have a qualified privilege. In other words, it's relatively hard for that former employee to successfully sue that former employer for defamation based upon a reference. It's not impossible, but it's more difficult. In Texas, the evidentiary standard that the plaintiff is going to have to prove isn't preponderance of the evidence, which is the usual standard used in tort cases, but clear and convincing evidence, which is a significantly higher hurdle for the employee to cross. And then there's also some additional statements. For example, the employer had to have known at the time he said it that it was false, whatever the statement was. So there is a fair amount of protection for the employer, but still, again, why expose yourself to any risk under those circumstances? Because keep in mind, most likely your call isn't being recorded, so how people remember what is being said, all the context, do you remember exactly what you said? It's easy to see how things can be misinterpreted and spun a different way, and so better not to give that information at all and to be consistent about that. Keep in mind that a statement that is true is not defamatory even if it harms your reputation. I mean, let's say Bob really did steal from you. And let's say your policy is, you know what, I'm just going to tell the world because Bob stole from me. Well, guess what? It's going to hurt Bob's career for sure. He's going to have a hard time getting a job, and that's not defamation. It's not even defamation if Bob has to tell future employers about it, because guess what? Bob did it. And you know what? He kind of deserves that outcome. So we're going to start, this is the new material. This is the stuff that I haven't previously covered in the third lecture. We have the topic of, actually we're not even going to cover, let's go on and talk about qualified privilege. I already kind of did this. This is that idea of conditional immunity. This is the idea that, and the idea of qualified privilege, the example I gave was of the former employer who was giving a reference. But there's lots of other circumstances in the law that provide for a qualified privilege in the case of defamation claims. The qualified privilege can be lost when the statement is made with malice. It's intended to harm the reputation of somebody, and of course it's still false. You always have to have the falsity, but the person who said it meant it to harm the reputation, or there was reckless disregard for the truth, or was there an overly broad publication of statements. Let me give you an example how this could play out. So let's imagine that you happen to have a workplace and you have a lot of turnover. You've had 10 Bobs work for you over the years, and you get a call from one day and they say, hey, listen, Bob Smith said that he worked for your facility 3 years ago, and I just wanted to check the reference. Well, you think to yourself, oh yeah, Bob Smith, I remember him. He had dirty blonde curls and a tattoo of an eagle on his arm. That's what you're thinking to yourself. And so you start saying, yeah, Bob's a pretty good guy. Oh, but you know what? He had a hard time getting into work. He was always late. And the potential employer says, oh, wow, thanks for telling me that. I don't want to hire him under those circumstances. So click, Bob doesn't get the job. And then you remember, oh, that wasn't Bob Smith. That was Bob Green. Now I remember Bob Smith. Bob Smith wasn't tardy a day in his life. Well, you didn't have malice. You didn't want to mess up Bob Green's life, or Bob Smith's life, but you kind of did have a reckless disregard for the truth. I mean, it wasn't really that you were acting with reckless disregard, but what you should have said is, you know what, gosh, I mean, that was 3 years ago, and I have a lot of turnover in my place. So, before I answer any of these questions about Bob, I'm going to have to sit down and review my personnel records. I mean, that's what you should have said if you were actually going to give a substantive reference. But you know what? I mean, that's a lot of work. You're probably not going to do that. You're probably going to wing it if you give a reference at all. But you can see how that sets you up for a reckless disregard for the truth. So you certainly did lie. I mean, as we've established, the real Bob, the Bob that was being called about, had a perfect tardiness record. But you misrepresent the facts. So it was definitely a false statement. And yeah, you were kind of reckless in answering the question without doing some research. So when you talk about a former employee, even in positive terms, but certainly in negative terms, you ought to speak only to those who you think have a need to know. And typically that's going to be within the organization. So it may be the line manager who's addressing Bob's attendance, maybe some other people in the HR department. Sometimes it might be people in the legal department. It may be an unemployment hearing officer. It may be the EOC if this matter gets escalated. But when would it ever be someone outside the organization? I mean, they may think they have the need to know that information. Even the former employee may think they have the need to know. But do you think they have the need to know for your purposes? No, don't think so. So you don't want to share that information unless you are required by law. And of course, you're not under these circumstances. Okay, so now we've talked about references. We're going to talk about verifying employment eligibility. This is an area of the law that has changed dramatically in the last 20, 30 years. And much of it is due to IRCA. IRCA stands for the Immigration Reform and Control Act, and it was a statute, I believe, passed in 1986 or 1987. And it has two important aspects. We've already talked about this one down here, but let me do a little refresher on this bottom one. If an employer has at least 4 employees, so we're talking really small employers, that employer is prohibited from discriminating based upon national origin or citizenship. And so this is actually kind of almost an expansion of the Title VII protection. You may recall Title VII protection kicks in only at 15 employees. Well, IRCA says, well, now we're going down to 4 employees. So IRCA really applies from the 4th employee to the 14th employee. Then after that, we get to the protections of Title VII. Now, IRCA is not as generous to employees in terms of the protections that it affords for national origin or citizenship discrimination. Actually, there isn't citizenship protection under Title VII, so this is the one that actually does extend beyond the 15th employee. But the protections for national origin is significantly less robust than it would be under Title VII. But I mean, heck, it's better than nothing, and Title VII wasn't covering people at all from the 4th employee to the 14th employee. So this is some additional protection. But that's not what people usually think of when they think of IRCA. The main thing they think of when they think of IRCA is employers can't hire people who are unauthorized to work in the United States. Either people who are here unlawfully or people who are here lawfully but don't have authorization to work. This was a compromise in 1986, I believe. This was a compromise that the Congress went through. They were doing some immigration reform, and part of that overall package was that they were going to be more robust in the hopes of, by cutting off the flow of jobs for people who are undocumented in the United States, that would the hope would motivate those individuals not to want to cross the border, because in many cases those individuals were crossing the border to come to the United States in the hopes of getting gainful employment. But if employers were not willing to hire them, then there would be no reason in many cases for those individuals to seek to come to the United States. And so the purpose of this law was to take away that motivation. And the mechanism that IRCA uses for that is it requires employers to complete a form that's called I-9. And the I-9 form has to be completed within 3 days of the date of hire, of the first date of employment. And it has to, through that document, the employee has to present documentation to the employer that that employee is eligible to work in the United States. I mean, usually there are 2 documents that the employee has to provide. Sometimes a single document can work if it meets 2 requirements. One of the requirements of the document is that it has to confirm that this person is who they say they are. And this usually involves a photo ID. So this might be a passport picture, it might be a driver's license picture, but it's a way that the employer can look at the document, look at the employee and say, yep, that's the same person. So some kind of photo ID. Then the second thing is some document that establishes that the name on that photo ID and then the name that the employee is saying that he or she has, that person is eligible to work. And in many times that's an unrestricted Social Security card. Probably the most common combination that employees have when they go to work is a driver's license and an unrestricted Social Security card. Another thing that sometimes people will use is a birth certificate of somebody who was born in the United States and a driver's license. A third common document that is provided is a U.S. passport, because obviously that's going to have a picture on it. Those are common combinations, but there are so many different ways you can prove this. And one of the things about I-9 is it is unlawful for an employer to say from this long list of documents, listen, we really just want these documents. You know, you need to provide one of these 4 documents. Forget about the other 50 that you might be able to provide. These are the ones that you want. That's called document abuse or document discrimination, and that's unlawful. An employee has a right to choose which documents to provide. In many cases, the employee isn't going to have all those documents. I mean, obviously, an employee who is here on some kind of visa or who has been naturalized isn't going to have a U.S. birth certificate. An employee who is not a U.S. citizen isn't going to have a U.S. passport. So certain of those documents aren't even going to be an option for some candidates. But these are common documents that a person would have. Driver's license, U.S. birth certificate, U.S. passport, a resident alien registration card, and an unexpired employment authorization document. But as I said before, there are lots and lots of others. This can be a very, very tricky process to figure out whether the documents that this person provides are authentic, and if they are, or do they meet the requirements under the I-9. One of my roles in private practice was sometimes to look at the trickier situations. It is not an easy process. I'm not going to lie to you about that. So it's something that requires a fair amount of expertise. It is saying, the vast majority of times it's a very straightforward situation, but you can get some really odd documents every now and again. So let's consider the categories of folks that we have. Of course, we have U.S. citizens. That's a category that isn't listed here. But another category are legal aliens. These are people who have the legal right to work in the United States, and they can work, without a limitation, and they shouldn't be subject to any type of discrimination. But there's another category of individuals. There's lots of different names for them. Some of those are somewhat loaded names that have some negative aspects to them. But common terms for that would be undocumented worker, or somebody who doesn't have correct documentation to be in the United States. Illegal alien is another term that is sometimes used for individuals who are not eligible to work in the United States. A program that the government has established is called E-Verify. It is not required for all employers, but it does have its advantages. It's an electronic system that allows employers to verify the eligibility to work of these employees. There's pros and cons to e-verification, and so I'm not going to go into a lot of specifics about it. It's definitely a decision that is made on an enterprise-wide basis after some reflection. Again, certain employers have to participate in it, other employers have some flexibility, and there are advantages and disadvantages to it. But it is definitely something that an employer wants to think carefully about whether they want to participate in e-verify or not. So now we have completed the process of implementing the hiring decision, So at this point in our first video, we talked about the recruitment of appropriate candidates. In the second video, we talked about testing. In the third video and in this fourth video, we've covered the hiring process, both making the hiring decision and implementing that hiring decision. Now we're going to move on to another topic, which is performance appraisals and overall disciplinary process. This topic is huge. These last two topics are really where most of the risk is in employment discrimination cases. I mean, the reality is if you don't hire somebody, they don't know why you didn't hire them. They move on. They apply for some other job, and for the most part, they kind of forget about it. I mean, there are absolutely failure to hire cases, but those are few and far between. So all the stuff we've talked about here, I mean, there are important compliance issues, but the level of risk is not very big. We start seeing real risk down here, though. Now, the real risk is at termination, but these performance appraisals and disciplinary process are the steps on the road leading to termination. So if you don't ultimately terminate somebody, then you're probably not experiencing a lot of risk. But really, when you're making negative comments on performance appraisals and when you're following a disciplinary process, you're doing it in many cases in the event that the problem doesn't get resolved. There's probably going to be a termination, and then you want to make sure you have all of your ducks in the row. So let's talk about it from that standpoint. So I guess what I want to say here is that this is a really, really big part of the presentation. I don't have a ton of slides on it. I'm not going to spend a ton of time on it, but just so you have a sense that there's a lot of meat here, or a lot of risk here that you want to be aware of. So let's first of all talk about the idea of performance appraisal. A performance appraisal can happen in lots of different ways. Different organizations have different methods. A common way is to have it on an annual basis. Many times the employee will have certain goals to accomplish. Some of those might be individualized to particular employees. Some of them might be enterprise-wide or department-wide or something along those lines. And then the employee is rated on particular skills. The rating system can vary. It can be, a numerical system. There could be a system where the manager has great latitude in how he or she rates the individuals. It might be that the manager can only give a certain number of ones, a certain number of twos, a certain number of threes. Lots of different systems along those lines. Sometimes the performance appraisals can be very mathematical and objectively driven. And some of this depends upon the particular job. For example, let's say that I am a widget tech. My job is to make widgets all day. So maybe the way to manage my success for that particular year is to see, well, how many widgets did she make? And what was the percentage of widgets that she made that failed quality assurance? Those might be the two most important factors. Let's say that I was more productive by 20% than the average for my department. That's pretty good, right? It doesn't probably really matter whether I tended to be late to work by less than 3 minutes every now and again, because that really doesn't affect my overall productivity. So, I might get a bit of a ding there, but really my productivity is what is at issue. And because it's something that's very easy to quantify, you can see how it would be easy to appraise under those circumstances. But many types of work doesn't lend itself to that type of appraisal. For example, HR manager, how do you appraise that person? I mean, you can look at metrics. You can say how many people did this person hire, how many performance appraisals did he or she do, but that doesn't capture how well she did or he did those particular actions. You can hire lots of people, but maybe you hired all the wrong people. And so those types of issues really require a more subjective, a more nuanced approach that honestly opens up the employer for the possibility of discrimination. Maybe the reason why the employer thinks Sally is doing a better job than Bill is because Sally really is doing a better job. And maybe the reason is that Sally is Caucasian and Bill or Ted is African American. And the employer has some kind of subconscious, unconscious, or perhaps even conscious racism. And so you want to think through, when you reach the conclusion Sally's better than Bill, well, tell me some specifics. Tell me an example of when Sally showed some better behavior than Bill, trying to get it to be as concrete as possible. So let's consider what the purpose of performance appraisals are. We want to identify performance characteristics that the employer hopes the employee will accentuate. So you want to communicate a culture. We really want you to be very productive and make lots of widgets. Well, that ought to be a big part of the weighing of the performance appraisal. On the other hand, if the value is we really want you to be here on time, that would be a different thing that we'd want to emphasize. So you communicate to the employee what that particular organization values. And then, of course, you want to discourage things that you don't want the employee to do. So you want there to be some consequences for that. The performance appraisal ideally should be a motivating tool, a way to cause that employee to adopt those characteristics that the organization wants. But it's also certainly a defensive tool. It's designed to protect the employer in the event that there's some kind of legal dispute. So the employer can say, This is why we did it. And look, all of our ducks in a row, we did everything just right. So you also have to consider the document from that perspective as well. And so you want to be careful and recognize that any performance appraisal could well be, exhibit 1 in the case, and you want it to be exhibit 1 for your side of the case, not exhibit 1 for the plaintiff's side of the case. The reality is performance appraisals can be very subjective. They can be not always done according to the schedule. I'll give you an example. I once worked for an employer as an HR attorney, and when I came on board, I was there for about a year, and one of the things that we did is we would fuss at various managers who weren't doing their performance appraisals on time, and we were told, you need to tell that manager to do a better job. And so when I had been there about a year, I asked them, I said, well, when am I going to get my appraisal? And they laughed. They go, you know what, every other department in this organization gets appraisals, but we never do. I've been here for 20 years, only been appraised twice. And that ended up being the case for quite a while. I wasn't appraised for I was told informally things, but I didn't get the performance appraisal. Kind of a case of the cobbler's children have no shoes. You don't want that to be your organization. You don't want there to be gaps. You want whatever the policy is to be enforced. And nowadays with electronic records, there's really no reason that you aren't able to enforce that policy. Okay, so you want to monitor the discrimination risk. Remember the prima facie case standard that we talked about in McDonnell Douglas. That is is that person a member of a protected class? Is that person qualified for the job? Is an adverse action considered being taken, such as termination or demotion? And are you going to be replacing that person from someone outside of that particular protected class? And so as you're thinking about that, certain performance appraisals become more fraught, more important. And so when you are approaching those that are more likely to get us down this prima facie case route, it doesn't mean you want to shy away from making the right decision with the organization, but it does mean you want to be especially careful. Pick your words, pick the right way of approaching it. So it doesn't mean lowering standards, it doesn't mean lowering qualifications, but it does mean to be aware that decisions made in the performance evaluation process have real repercussions, and everybody ought to be on board and understand what those are and have thought through how to present those in the most effective way for everyone. Hopefully, of course, that the employee will turn a corner and be successful. But if that can't happen, considering how the jury would react to it is also a very good idea. Let's consider a scenario. So we have Bob again. He's an Asian man who is a project manager, and he's about to receive his first performance appraisal in his new job. On the appraisal, his supervisor states, compared to other project managers, Bob falls below expectations in the performance of his job duties. He has missed 4 out of 6 deadlines in the past year without justification. Bob needs to improve his time management skills. Let's assume that these statements are accurate and truthful. This is a very good performance appraisal. It's very concrete. It's not, it's 4 out of 6. I mean, this is a true statement or it's not. And so because it's provable one way or the other, it's objective, and it doesn't rely upon any of his protected characteristics, this would be very good. Let me kind of rewrite this though and show you how an appraisal might not be good. Compared to other project managers, Bob falls below expectation performance of his job duties. He's just awful at his job. We would expect more from somebody like Bob. Bob needs to improve his time management skills. There's nothing concrete there. It's not even, other than time management skills, we don't have anything concrete to hang our hat on. We need to be specific. This is what Bob does that isn't helpful. This is what he needs to do more of. And so be as clear as you can. This is a pretty good example. You might even want to get more granular when you're actually talking with Bob about that and go through the 4 deadlines that he missed. Okay, so let's talk about discipline. Let's talk about the idea of just cause. We've talked about employment at will at length before, and we've probably talked about how that's in contradiction or in opposition to the idea of just cause. Just cause is the idea that you can only fire people, or employers can only fire people when there is just cause for the termination. Again, that's not the standard for the vast, vast majority of us in employment. You usually see that in some governmental positions and in union operations. So the standard isn't just cause. So you may be saying, well, Gruber, why are you raising this? Because we're in an at-will employment situation. Well, while employers ought to zealously protect their at-will employment designation, they probably, as a practical matter, ought to approach their terminations other than when times are tough and layoffs have to happen. I'm going to accept that category. But they ought to approach terminations that are done because of disciplinary reasons through a just cause standard. Why should they? Well, again, the case can get before the jury, and juries a lot of times aren't so focused on was the letter of the law followed exactly. No, many times they look at it and go, does this termination feel right to us? Do we feel that the employer was really reasonable in how he handled the situation? And one of the things that the juries want to see, frankly, is due process. We have this term in the Constitution about, due process of law, things like that. We had that in the Fifth Amendment. We had that in the 14th Amendment. Of course, in neither one of those places does it apply to private employers. There is no legal obligation that an employer provide due process to his or her employees. Having said that, you want to definitely think in these terms, because that's the way the 12 people on the jury are going to think about it. That, well, did Bob get a fair shake? Was he given opportunities to change his behavior? Was he able to uh, do the things necessary to, were the expectations reasonable? Was he given a chance to be heard? All of those things are part of that due process bundle. And so you want to make sure that you've given Bob those opportunities, and that they're not just window dressing, that they were sincere efforts to get Bob to turn the corner. Is it a requirement under at-will employment? No. But keep in mind, most of the time the employer is going to be alleging something like some type of discrimination. And so the at-will standard really isn't the key here. Now, the issue is, well, was there discrimination? Yes, it's an employer can fire people who show up to work. Hey, today I'm firing anybody who's wearing the color yellow. But you know what? The jury's not going to believe that you fire people because they're wearing yellow, especially if it just so happens that an African American is one of the people who happened to be wearing yellow that day. Instead, the jury's going to think, well, yes, he had the right to fire people wearing yellow, but what a big coincidence. The one day he decides to fire people wearing yellow, the African American employee happens to be wearing yellow on that day. Looks like too much of a coincidence to us. I don't think he was exercising his at-will employment rights. I think he was discriminating based upon race. And it's going to be pretty hard to persuade a jury otherwise under those circumstances. So due process is your friend. You want to document this. Every time you have a conversation with Bob about his performance, even when it doesn't result in a formal written document, make a notation in your calendar. Spoke to Bob at 2 p.m., reminded him he needs to da-da-da-da-da, whatever the thing is. Another really important term in this context is progressive discipline. When I use the word progressive here, I'm not talking about any kind of political statement. I'm talking about progress, and that's a step-by-step system that we might have. And so a progressive discipline would start out with a relatively small discipline or disciplinary action the first time it happens, and then escalating to more serious ones. Let me give you an example. Imagine that an employer has a tardiness policy. The first time that a person is tardy, he gets a verbal warning. The second time, another verbal warning. The third time, a written warning. The fourth time, a written warning and maybe maybe it's an escalated, a second written warning maybe. The fifth time in 6 months, and the employee is suspended for a day. The seventh time, and the employee is suspended for a week. the sixth time the employee is suspended for a week, the seventh time the employee is terminated. That would be an example of a progressive disciplinary process. By making the consequences more and more severe, the employee is getting the message, oh, wow, they really mean this. And you know what? I can see where this ends. And every single time they've taken the step that they've told me they're going to take, and I can see I'm 1 or 2 steps away or whatever, how many steps I'm away from being terminated. So I need to probably change my behavior so that doesn't happen to me. It's a very good idea to have progressive discipline. If you have that type of system, you want to make sure, though, that you follow it. And so having an awesome progressive disciplinary process is awesome, but it's not so awesome if you don't follow it. If you are supposed to give that written warning on the 3rd tardy, and you know what? The supervisor doesn't usually do it until the 6th. Not so good. Or sometimes the supervisor does it on the 3rd, and sometimes it's the 4th, and sometimes it's the 5th, and sometimes it's the 6th. Well, let's just assume that the supervisor covered that disciplinary interview promptly with the women in the department, but not with the men. I mean, maybe it's just a coincidence. Maybe the workload was such that he just had the ability to have that conversation at the right time. There was no sexism there at all. I mean, maybe that's the case, but is the jury going to read it that way? No, the jury's going to see that there is some sexism. So when you have a progressive disciplinary policy, you want to make sure that you follow it quite consistently. And part of the role of HR is to make sure that it's followed consistently. And supervisors and managers who don't do it, they need to be put on a progressive disciplinary process. So now we've talked about performance appraisals and disciplinary process, and now let's talk about termination. This is oftentimes called the death penalty in employment law. It's what severs the employment relationship. It's the most severe thing that an employer can do to an employee, and it's usually the basis of whatever a lawsuit might be. Now, obviously, employers routinely fire people who don't sue. Most of the time, employees don't sue when they are terminated. However, when an employee sues, in the vast majority of cases, it's a situation involving termination. I'll tell you, I've litigated so many cases, and it was very, very difficult to predict who was going to be the person who filed the lawsuit. There were many times where I was absolutely certain that a certain person was going to file a lawsuit once we fired them. And, sometimes they did, but oftentimes they didn't. Wow, big surprise there, no lawsuit. Then there would be other cases where I was persuaded, oh, there's very low risk. I mean, the facts just aren't good for this person. I just would be very surprised if they sue, and they do. The takeaway is there's just too many variables in that equation to really know the likelihood of a lawsuit. So you have to approach all terminations as if there is a risk that they will result in a lawsuit. You want to assume that the worst case scenario so that you're prepared for it. And again, that means document, document, document. So obviously, for termination is the single most risky employment decision that an employer makes, at least from a legal compliance standpoint. So when you terminate somebody, even somebody who you are just sick to death of, somebody who you consider a really bad apple, who maybe is stealing from you or sexually harassing people or doing all kinds of terrible things, sometimes there is the temptation to be mean or to be vindictive. Don't do it. The jury is the potential jury is not going to be impressed by that. Even the worst people, when they're being fired, can get sympathy because everybody can imagine being in that room and receiving the word that they are no longer welcome at this place of employment. So you always ought to treat individuals that you're terminating with courtesy, respect, and privacy. You want to give them as much dignity as they can muster. For one thing, it creates a good fact for you in front of the jury. For another thing, it probably makes it less likely that person is going to sue you, which is a good thing. And finally, it makes the interview more comfortable for everyone. a person who you are being mean to, who you're firing, is likely to lash out, and maybe even potentially in violent ways. And so by diffusing the situation, you are putting yourself in a better position overall. So be sure to remember that. If you can't handle the termination calmly on a particular day, better not to do it that day, or to ask somebody else to do the termination. So now we've completed the elements that we have. We've talked about the recruitment of appropriate candidates. We've talked about testing, the pre-employment testing of those candidates. We've talked about the hiring decision, how to make it, how to implement it. We've discussed performance appraisals and how they impact the disciplinary process. And finally, we've discussed how we would approach the termination of an employee. Here's some things to think about. I call them boulders, kind of the big things that you want to keep in mind. Document, document, document. Document performance appraisals, document the hiring process, document the interview questions, document the disciplinary interviews, document the termination interviews. Train employees, the supervisors, about how to conduct the progressive discipline, how to conduct the appraisals, how to do the interviews. And it's not just a one-time thing, it's a process of training, training, training. And then evaluate performance of your employees frequently and systematically and as methodically as possible, removing as much as possible the subjective element, especially when the subjective element could be unfortunately combined with some kind of hidden, or maybe not hidden, bias that a particular manager or supervisor might have. I hope that this presentation has been helpful for you. As always, it's been a pleasure presenting this to you. If you have questions about the material, please don't hesitate to contact me. Please send me an email or stop by my office hours. I would be delighted to talk with you in more detail about these topics. Again, thank you for your attention and have a wonderful day.